Good morning, everybody, and welcome to our webinar on data protection and GDPR. First of all, let's do some introductions. Our main presenter today is Victoria, our HR Knowledge Manager. I'll be here to help field some questions, and we also have a team who's online to help with any technical issues that any of you may have. So do let us know if you're struggling to hear or if there's any problems, and she'll try and help you. So how to ask questions? We've had to put you all on mute. There are hundreds of you attending today, so we need to make sure that we can hear everybody and everybody gets a chance. So we do want to ask you to ask your questions. You should have a panel, something like this. Please put your question in there. It'll come through to us and we will field them. A team will help with any technical questions and I'll help collate any relating to the topic today. We do want you to be involved as much as possible. So we are going to be running some polls. As soon as you see this screen, you know we're about to run 1 or 2 polls to ask you some questions about the topic. So before we go any further, I'm going to hand over to Victoria. Who's going to take us through the webinar. Thank you, Victoria.
Thank you very much, Sue. Let's share my screen.
Just switching it going.
Thank you. There we go. We should all still be able to see my screen. Brilliant. So good morning and welcome everybody to today's webinar, which is all about data and GDPR and compliance and implications after Brexit. So we do have quite a bit to get through today, and it's perhaps not the easiest of subjects to, I guess, get your head around. So I'll do my best to help provide as much clarity as I can for you all. And so I'll begin with firstly explaining the relevant key points about data and GDPR as it was before Brexit, before then sharing what the key changes have been in respect of data and compliance now we've left the transition period, so everything essentially since the 1st of January this year. And as part of this, we're going to be exploring what we mean by an adequacy decision and the potential implications for the UK. I shall then cover off international data transfer rules before closing the webinar with some recommended practical next steps for you all, some things that you can be doing right now. And then finally, given the complexity of the subject, I'm going to be highlighting to you where you can access further relevant information to assist you moving forward. And then we'll have questions at the end. So in regards to questions, I'll do my best to answer as many as I can this morning. Just drop the questions in the comments as Sue explained. Any that we can't get to today, then I will be following up with you all afterwards. Or if there are any that are particularly quite complex, again, I'll perhaps leave those and follow up separately. So we're going to begin with a quick poll. So I'm just going to invite Sue to open up the first one for us, just to sort of understand where we are in with regards to data now we've left the EU. So Sue, if I can ask you to set up the first poll.
Yeah, just launch that one. So
thank you.
Have you considered data protection in your organisation since the UK left the EU? I think that's significant.
Okay.
Steer one way. Let me just close that poll and share the results with you. So we've got 70% have.
That's good to see.
Haven't. It's a good sign.
And hopefully today will help those haven't probably have some things that they can take away and start thinking about.
Yeah, absolutely. And so we can just get a feel for the people attending today and their kind of location within the EU and otherwise. I'm just going to ask the next one, which will be, do you have offices within the EU or EEA, first of all? Okay, so let's close the poll and share the results. So we've got,
Okay.
well, most people that don't,
Okay.
but still quite a number though that do have offices. So we've got
Yeah.
data both ways we need to consider today. So so let's just ask the next question, which is whether you send or receive data from any EEA or EU country.
Oh, interesting, this one.
Yeah, a bit more evenly split, isn't it? Okay, let's close that poll and share it. That's an
Oh,
interesting one.
wow. Have we had 50-50 before?
No, I don't think we've ever had it so equal. So there we go. So yeah, there's a good number of us that actually send or receive
Yeah.
data, which is good to hear. And so our final poll for this section is about international transfers again. So this is, do you deal with the international transfer of personal data? This is countries outside the EU or EEA, which is slightly more challenging.
Yeah.
Okay, I think nearly everybody's voted now. Yeah, okay, I'm going to close that and share those
Okay.
results. So there we go. 61% don't, but 39% do. So again, it's some significant numbers here, even though
Yeah.
the balance might be one way, in actually are transferring data. But it's surprising, isn't it, where data comes from, and all of a sudden when you do an analysis, what there is. Okay, so I'll hide that and
Thank you.
come back over to you.
Yeah, thank you. And that
Continue.
those polls will suggest that hopefully everybody will find the content helpful this morning. So let's move on. So I'm just going to first of all just cover data protection before Brexit. So first of all, you'll all be familiar with the GDPR. It is an EU directive which applies to all organisations that are based in or do business in the EU and EEA, regardless of size or sector. And it was introduced back in 2018, and the purpose was to bring about one single set of protection regulations applicable to all EU member states in the same way. And so when the UK was in the EU, it meant that UK employers could transfer data freely between all other member states and without restriction. The GDPR also places restrictions on companies when transferring personal data to a country outside of the EU. So for the 40% of you on the call this morning, you're already familiar with what's known as international transfers. And so for the UK, data could not transfer freely to a country outside of the EU because of several obligations and restrictions that are being put in place or have been in place, and certain measures, have had to be taken. And then alongside this, we've also had the Data Protection Act of 2018. Now, that wasn't the very first piece of data protection law. We've had it in place for a number of years. But the Data Protection Act of 2018 is the UK's own legislation governing the protection of personal data, but its content is primarily derived from the GDPR, because as a member of the EU back in 2018, we were required to adopt it. And so our Data Protection Act of 2018 essentially covers our responsibilities under the GDPR. Now, for the purpose of this webinar, I'll probably interchange between the use of EEA and EU, but essentially all those countries are relevant to what we're talking about today. And when I talk about data, I mean personal data. So this next slide is actually, I just thought it would be quite helpful to give you a visual. This is the European Economic Area, the EEA, and it's effectively made up of the EU member states plus 3 additional countries, which form part of the European Free Trade Association, and that's Iceland, Liechtenstein and Norway. with Switzerland excluded. Now, this image is of when the UK was in the transition period, so just before the end of last year, hence why it's in the light green. But it is just useful just to show actually this is how our data has been able to be shared freely up until obviously the end of the transition period. So essentially up until the 31st December last year, if your business has had an overseas office in any of these countries within the EEA, then your employee personal data has been able to transfer freely. So I thought that was quite a useful visual. So we're now going to focus post-Brexit, so January the 1st onwards. And so as a result of Brexit, we now have what is actually called the UK GDPR. And this has come about as part of the European Union Withdrawal Act of 2018 and as amended by the Data Protection, Privacy and Electronic Communications EU exit regulations of 2019. So that's a bit of a mouthful, but essentially it's come about because of our exit of Brexit. So it has also been defined in Section 3 of our Data Protection Act of 2018. And so what it means is from the 1st of January of this year, for all UK-based organisations, the legal frameworks for managing personal data come from both the Data Protection Act of 2018 and what is also now known as the UK GDPR. The UK GDPR also complies to controllers and processors based outside the UK if their processing activities relate to offering goods and services to individuals in the UK or monitoring the behaviour of individuals taking place in the UK. So now we're out of the EU from the 1st of January. It means that the free transfer of data has ended because for the purpose of the GDPR, we are now considered a third country. And so this means the data flow between the UK and any of the EU member states is deemed as an international transfer and therefore subjected to restrictions. So I know there's 40% of you listening today that have already got experience of dealing with international transfers. So you probably will know to some extent what that means, but I will be coming into detail shortly and talking more about international transfers. But essentially, we are now a third country. And so what that means is that in order to safely and lawfully transfer personal data, then additional safeguards are required. And so additional safeguards can include things like having a legally binding instrument, having standard contractual clauses, which are known as SCCs, or having binding corporate rules, which are known as BCRs. And so, as I said, we're going to discuss these more later, but I just wanted to flag really before we move on that although technically the UK is a third country and transfer restrictions must therefore be in place, in actual fact, what's happened through the trade negotiations, the EU have granted temporary provisions via the trade deal to delay transfer restrictions being in place or imposed on us. And so we've got this grace period of 4 to 6 months. And so that grace period will allow UK organisations to still send and receive personal data within the EU for the time being, giving UK businesses that time to prepare. So technically we are a third country, but in reality, in a practical sense, the EU have granted that transition period to allow us time to move to that position. So that's where we are at the moment. And the next piece is really important in regards to this grace period, and this is all to do with the adequacy decision, which I'm going to just explain what it means and the implications of it. So because we're in this temporary period of being able to, even though we're a third country and we should be dealing with international transfer of data when we transfer data to EU countries, we've got this grace period, and so we still are able to freely transfer data. And it's hoped that the UK can be granted what's called an adequacy decision. An adequacy decision is a legally binding and enforceable instrument which would be deemed as an additional safeguard in the transferring of personal data. So i.e. it would allow us to transfer without restriction the flow of data between the UK and any of the EU countries moving forward, despite having left and despite being considered a third country. So it's essentially, we need to get approval from the European Commission that the UK is a country which protects personal data up to the standards of the EU GDPR. Now, given that the UK have always maintained very high standards in regards to data protection, we've obviously had the GDPR rules in place for some time. The government moving forward are committed to those high standards. I suspect that, you know, we're already meeting high standards in the expectations and eyes of the EU. And what happened back on the 21st of February, the European Commission published a draft decision and actually did find that the UK to be adequate, i.e. it was able to send data lawfully and fairly. So it is only a draft decision and it is looking promising, and bearing in mind we have had high standards for the last few years around data protection. However, technically it needs to go for final review by the European Data Protection Board and a committee of 27 EU member governments. So if they approve the draft decision, it's going to mean that the European Commission can formally adopt them as a legal adequacy decision, which will mean the UK can allow the free flow of data under the EU GDPR transfer rules, as it has done up to now. Whereas should the adequacy decision not be adopted, then the UK must comply with the EU GDPR transfer restrictions, which are currently in place for all other third countries, as it does now. So I suspect, you know, there's a strong chance it's going to be granted. Obviously, who knows? Nobody knows. And I guess it's an opportunity for the European Data Protection Board to actually really analyse, does our UK GDPR rules that we've now brought in because of Brexit really still honour the letter of the law and as the GDPR was intended? So we shall see, but as it stands, it is looking positive, but it's important information and something to be looking out for. So I just want to ask a quick question through the poll. So Sue, if you could kindly put the next poll up. And this is all about, do you feel you're prepared should the adequacy decision not be granted? So effectively, you know, do you think you're prepared as a company to deal with international transfers if you're having to send data to France, Germany, or any other EU country?
Just
it's
a few more vote.
Thank you, Sue.
I think most of us are just on the real hopeful assumption
it will get granted. Yeah.
We like everything European.
Yeah.
I assume it will be sorted. Right, okay, I'm going to close that poll and share the results with you.
Okay. So yeah, so 68% of you feel that you're not prepared, and
yeah.
it's yeah, I mean, it's going to be a huge amount of work, isn't it, if the decision goes against what we're hoping it to be. And so hopefully the rest of this webinar will help answer some questions and we'll sort of think about some practical steps to take. But yes, I think the key message here is we need to start preparing for what if we don't get that adequacy. So thank you, Sue.
Okay.
Okay, let's move. So I'm now going to talk about international data transfer rules, because obviously if that decision doesn't get granted, then we need to be mindful about, you know, we've got to operate within them. So should we not get the adequacy decision, then UK-based employers will need to adhere to Part 3, Chapter 5 of the GDPR, and this particular section deals with the transfer of personal data to that third country. And so that we also have the Data Protection Act of 2018, which also limits the circumstances when data can be shared. So what this is going to mean is that in order to be able to transfer data, first of all, the transfer has to be necessary for any of the law enforcement purposes. Secondly, the transfer has to be based on an adequacy decision, or if not, appropriate safeguards, or if not, then when the transfer is based on special circumstances. And then finally, the intended recipient is a relevant authority in a third country or is a relevant international organisation. So as you can see from these three aspects, it is absolutely crucial that we get that adequacy decision. Otherwise, we're going to have to think about the safeguards, or are there any special circumstances, etc. And just to note, where the transfer is not to a relevant body, it can still be possible to transfer personal data, but it must meet other certain additional safeguards. So in terms of Chapter 5 and the Articles 40 to 50 of the 44 to 50 of the GDPR, UK businesses have to comply with that aspect. And so should that adequacy decision not be adopted, there are several points really that businesses should be given consideration to. Firstly is a data transfer caught by the data protection requirements on international transfer. And in considering this, then the following must apply. So there has to be a transfer of data, and that data is personal data and or special category personal data. The recipient is not subjected to the GDPR. The recipient is a separate organisation or individual, even if the recipient is another company within the same corporate group. So firstly, they're the considerations that you need to give thought to. Secondly, well, is there an alternative to transferring personal data outside of the UK? So for example, are you able to make the data anonymous so it's never possible to identify the individuals? Or using an alternative supplier perhaps that's based within the UK? Thirdly, then, is there a lawful ground for processing under Article 6, which is all about lawful basis for processing data, or Article 9, which is about processing of special categories of personal data? So for this, it's about considering, lawful grounds for processing, which could be consent, contractual performance, compliance with a legal obligation, and then establish whether you can transfer under one of the valid mechanisms that's relevant to international transfers. And so the relevant mechanisms are the things that I've just said in terms of your adequacy decision, having appropriate safeguards, which can be your standard contractual clauses or binding corporate rules, so your SECs or your BCRs. And then finally, is there a lawful mechanism for the international transfer? If not, then what should be done? So where there's no lawful mechanism, so you haven't got the adequacy, you haven't got the safeguards, etc., then transfer of data must be suspended. But organisations can seek alternative mechanisms at that point, which if you are at that point, then perhaps more legal advice around data protection is probably going to be needed. But there are potentially other avenues that you can go through to derogation, for example, that could help facilitate the transfer. Now this flow chart that I've just put here is almost like a checklist to help in the thought process to understand if you're lawfully able to transfer data from the UK to, say, a European Union country, where we don't have that adequacy. So the first thing to consider is, are you planning to make a restricted transfer out of the UK? Well, if you're not, then you can still make the transfer. But if you are, so you are going to be transferring to France, Germany, Spain, then you need to go to the next question. And that is, do you need to make a restricted transfer of personal data in order to meet your purposes? And so, no, then you can make the transfer without personal data. But if there is, then you're going to need your adequacy regulations if you're going to be making the transfer. And if you've got the adequacy decision that we're expecting, hopefully fingers crossed, then you can make the transfer. But if you're not, then you're going to have to put in either appropriate safeguards, and you can look through either undertaking then a risk assessment, and if that shows that you're satisfied the data subjects continue to have protection, then that will be sufficient to make that transfer. But if it doesn't, then you need to find an exception that's provided for under the UK GDPR in order to apply. So there's a bit of a data flow and some questions to ask, and I'll provide the link to the ICO, which is helpful. It gives you the checklist when we distribute these and the slides at the end of the webinar. So I guess just to summarise then, we're all hinging on this adequacy decision, because if we get that, it means we can continue to transfer data between the UK and a European country freely. But we still need to take steps and prepare for the potential of it not being granted. And so these next few slides are just some of the tips and recommendations that just to run through with you that you can look to take. So first of all, keep your eyes peeled and look out for that adequacy decision. Of course, we will always share any updates that get communicated once we know, and so just keep looking and checking our website, knowledge base. You can also use the Information Commission Officer's interactive tool to help you understand whether the end of the transition period affects you. So that's a useful link for you to have a look at. If you are a UK business with no contacts, employees or customers in the EEA or EU, then nothing much more needs to be done. But you may still wish to review your existing work practices to ensure data protection compliance, and so we've got a free tool available on our main website which can help you do that. We have a data protection risk audit, and again the link to that will be on the slides afterwards. And then on our next slide we talk about if you have if you deal with processes that are responsible for the personal data of any individual who resides in the EEA or EU, you'll need to comply with both UK and EU data protection regulations in respect to how they process their data, regardless of the geographical location. And so it would be advisable to designate a representative within the EEA if your organisation has a presence within it, so you've got that point of contact and somebody to work alongside with from a data protection perspective. Then we would recommend review your data flows, because you need to be able to identify where you receive data from and or where you send data to within the EU and EEA. And if you receive personal data from the EU and EEA, we advise ensuring you've put appropriate safeguards in place as soon as possible, and preferably by the end of April, in case the European Commission's draft adequacy decision is not adopted. Now they did indicate of a period of 4 to 6 months, so who knows, it could be that we don't get to know until May, June time, but still as soon as possible look to start preparing and putting in any safeguards that you can. Liaise with any European representatives or organisations you may work with about what, if any, additional safeguards need to be in place to ensure that legal flow of data between your UK operations and those based within the EU. And if the UK does not receive an adequacy decision, it's very likely you'll need to put in place standard contractual clauses as a safeguarding measure in respect of data coming from the EEA. And these are a set of rules which deal with how you transfer data from the EU to the UK business. Another safeguarding measure for data coming from the EEA would be to undertake, as I said earlier, a risk assessment that's relevant to that data transfer. And the Information Commissioner Office has got a tool available, Keep Data Flowing tool, that you can use to help in that process. Where you do have data flow from the UK to within the EU, document the new basis for that data transfer. And where you transfer data to the EU, then there is no action required. You can still send the data, however, be sure that all your privacy information and other records are up to date. The UK GDPR currently does not require any safeguards for transfer of data to the EEA. Now, if you collected data before the 31st of December 2020 concerning employees based in an office, branch or other established presence within the EU, i.e. so it's non-UK data, then this will be known as legacy data, and it is subject to the EU GDPR regulations as of 31st December, and it's also known as frozen GDPR. So you may still use the latest information you hold regarding where people were living up to the point of the 31st December, but personal data acquired from the 1st of January that is processed based on the Brexit withdrawal agreement is also subject to the frozen GDPR. Following on from the previous point, then it's also advisable to undertake a one-off exercise to identify the data you have collected before the end of 2020 about employees living outside of the UK at the time, and this will be required for compliance purposes. Review your company's privacy information, internal records and logs to identify what may need updating should the draft adequacy decision not be updated or adopted. And all those responsible for and involved in data protection within your organisation should be kept informed, kept up to date on the transition period, and provided with appropriate training on managing data safely and in line with data protection requirements. So because data protection laws can be quite complex, obviously we know at high level there's certain responsibilities that we have in regards to processing data on a day-to-day basis, but we've got a lot of information available ourselves on our website or through the knowledge base. So we do offer that free data and compliance risk audit, so the link is available here, and we have many webinars that we put together that you can watch on demand, that they were put in place at the time of GDPR. Now just bear in mind that they are related to the GDPR from 2018 when it all got introduced, but we have, through creating the UK GDPR legislation, which is now in place, it is based on it, so they will still be useful and helpful. But just bear in mind they are older webinars. And then our knowledge base, for those of you that are members of it, then you can access our GDPR toolkit, and there's lots of useful forms and guidance and articles on there in regards to that, as I've listed here. Now externally, in terms of further information, then there's a lot of good advice and information out there on the Information Commissioner's Office, which I would encourage. So there's literature in regards to international transfers, data protection after the end of the Brexit transition period for small businesses and organisations. You have an interactive tool that can help you work out how you keep data flowing from the EEA to the UK. And there's an end of transition. Again, it's another interactive tool for small businesses just to help you work out what perhaps you may need to do when we, in terms of following Brexit. So that brings me on to the opportunity to invite questions. So, Sue, I don't know if we've had many questions.
We have. In fact, they're just literally just coming in as you were finishing that last slide. So I'm just reading through them now. There's a question about there's little or no guidance about using like MST, Microsoft Teams and other recent platforms used for remote working. It's interesting. Microsoft do publish their data security profile, so you can research what they guarantee they are using, and in most cases they're using European servers. So we've done it ourselves as part of a risk assessment when we moved over to Microsoft for all of our kind of supporting technology. We've reviewed their data security profiles, and we were reassured, and that's part of our own ISO. So they are aware of it, and they are doing quite a lot. So it's really, you're saying, is there any policy wording? I'm not sure if it's for your data protection policy. then usually you'll be saying that for all your suppliers that you have obtained or have in place a data protection agreement. It's very difficult to get any agreement with Microsoft, but I say we've instead gone for just reviewing it ourselves and being reassured ourselves of what they provided. So the next question is about we already undertake international transfers. If the UK is no longer governed by the GDPR rules, will our existing measures, which were put in place because of the GDPR regulations, still be valid? I think you started to touch on this, didn't you, at the end of the presentation?
Yeah. So for existing measures and mechanisms that are in place, then they can continue for the time being. So that shouldn't be an issue at the moment, because I'm just thinking. Yeah, so international transfers, if it's already outside the EA, then it can continue if you're relying on the same mechanisms. Sorry, I was just trying to remember. There's so much data protection stuff in my mind. So yes, and yeah, so you can continue with your existing mechanisms. So you'll probably have your SCCs, won't you, your binding corporate rules. And I believe the ICO have confirmed that.
Okay, yes. And one of the questions which you also covered off was, do we know when there'll be a decision on adequacy status? I'm aware that the European Data Protection Board met this week on the 13th, yeah. And they have given they reckon there is a strong indication that we are in alignment with them, and they've asked for further reviews on, as probably not surprisingly, the immigration side, yeah. Which was always a sticking point before, and one or two other areas, but generally they are, looks like we're heading the right way. So okay. There's no indication of timescales still, but they've just asked them to review a couple of areas. But yeah. They say they are. There is a strong view that they are broadly in agreement with their principles, because we've adopted them. But there's just a few areas where we differ, as always. Yeah.
Like I said earlier, we've adopted the UK GDPR is based on the GDPR, isn't it? And our data protection 2018 laws incorporate GDPR, so we already have high standards, don't we, in regards to data, and it's just whether we've created our UK GDPR sufficiently in the eyes of the law and as it's intended, I guess.
And it's also the apparently it's to do with the onward transmission as well. If you're going onward transmission to other international countries, that area was one of the other areas they've asked us to sharpen our pencil on a bit, I think. So as well as the immigration, some of the issues around immigration. Yeah. So but I think we're close. Hopefully they're surmountable.
Yeah, and they did grant up to 6 months, didn't they? So assuming it started from the 1st of January, so 4 to 6 months. So we're not that far away, especially if they've met this week.
And they'll take it to the wire, as always, won't they?
Yeah. But it'll be so much easier for all, won't it? Just having it granted.
Yes. But, so somebody's asked about it. So they understand there'll be new standard contractual clauses released this year. I think we've already got them, haven't we? Because they're on the ICO site. They gave some very detailed. Yes. They're like 40-page documents, by the way. Yeah. They're not just a little clause that you can stick in your contract. They're meaty documents, and it's all around how you are protecting data. But it is at least something that a company can do on their own, whereas to try and get the binding, the BCRs in place, that's more, you'd want organisational representatives to try and organise those, because you have to do them in liaison with the ICO, whereas at least standard clauses you can put in place yourself. So yeah, I think they should be, if you go on the ICO and search for standard contractual clauses, you should be able to get them. But we can send you a link or copy them. Yeah. We'll put the link in the presentation at the end before we send it round.
Yeah.
just seeing if there's another one. If we complete a risk assessment to understand whether we can transfer data, if we're not satisfied from this that the data continues to have protection equivalent to UK data protection requirements, what else can we do?
So you would need to look to see if there is an exception that's provided for your situation in the UK GDPR rules that have come about, just to see if it applies, these exceptions can apply to your situation. And I think I would suggest perhaps for interpretation of the law, you'd probably be best speaking to somebody that specialises in data protection, so legal advice around that. But it's not that you potentially won't be able to, it's just that you'll need to see if there's an exception for your circumstances within the law.
And I think there's a difference between the lawful basis for sending it, having to send it overseas, and also or processing it overseas, and giving it adequate protection, isn't there? There's two kind of aspects to it. So if you have a lawful basis for processing it, but you aren't able to give it adequate protection, then you probably shouldn't transfer it. So it's all about protection to the right required standards. I think finally, you recommend perhaps having a representative within the EEA when we process personal data within the EU. Who would you suggest?
Okay, so I guess just similar to perhaps how we operate now, in the UK businesses generally have data protection officers. So it could be in somebody in your overseas office that holds a similar role, or somebody perhaps in a position of authority. I guess you just got to look at the roles that you have in your overseas office and see where it's best placed. But it's down to each organisation to determine who they have in that role. And somebody that can focus on data protection.
Okay, thank you. Oh, actually, we've had one interesting question to do with lockdown being eased and people taking temperatures of staff.
Okay, yeah.
If they've had one of these facial temperature units installed, and if it sends an alert to the employee's manager, to say the employee will have to leave the office, can that be viewed as storing data? How long can it be stored, and is it deemed as an employee medical record? We've just recently looked at this, haven't we?
Yeah, and the whole testing, vaccines, mandating them debate is obviously still ongoing. And yes, it is all data. In fact, it's special category data, if I'm not mistaken. So, there are even further measures you have to put in place to safeguard it, because you're talking about somebody's medical record. So yes, so your normal, usual data protection responsibilities, just as if you're holding sickness absence data, remain in place. I don't know if you've got anything to add there, Sue, but it's a very interesting topical point.
Yeah, I would say it's protected. It depends on, and storage would be an issue, and you'd have to look at who has access to that data and how you protect it. So and how long do you keep it for? Well, how long do you need to keep it for? I guess once you've made the decision to send them home, then you no longer need it, really. You've used it for the purpose for which it's needed. So you probably shouldn't store it, and maybe that'll limit the risks of having it. Because you only should keep it for as long as you need it for the purpose that you took it for in the first place. So I would guess that's what you need to look at.
Yeah, and so that was interesting then, because data that relates to somebody's testing, the temperature testing, is different to somebody, whether they've had the vaccine, because there's a lot of discussion at the moment, isn't there? It's a very topical debate about asking your employees, or can you mandate employees to be vaccinated, and there's a whole load of risks around that. But Yeah, so how long you hold it is very dependent upon what it is you're dealing with. Each is going to be very different. So testing and vaccines are two very different subjects, aren't they?
Yes, absolutely. Sorry, I'm just sneaking another one in because they're popping in.
That's good.
Somebody was asking, with American companies, some are trying to rely on the old agreements that have been in place. I think you're referring to the Privacy Shield. There is a huge amount of pressure on America to get this replaced. It was very difficult because of their laws are different in every state. So whatever they put in place is always challenging for them legally. But Europe are putting on a huge amount of pressure to them to get something, you know, to replace the Privacy Shield or its equivalent, so that companies can sign up to it. But that is a real challenge. Is transferring data to America at the moment. And especially if it's on American servers. So you would need to really follow the guidance, you know, undertaking risk assessments and looking at what protections you can afford, and whether, the first question, I guess, is, do you really need to send it there? Because there is a risk at the moment without the adequacy status. So are there any implications, sorry, for data access requests? I don't think they've changed, have they? I don't think they've changed anything with subject access requests?
No, the thing, really the key thing is the flow of data. That's the thing that's coming out on the back of Brexit. Pretty much everything else in regards to data protection and how we process and handle data day to day is pretty much the same, because, like I say, the Data Protection Act of 2018 is underpinned by GDPR standards and rules. And now we have the UK GDPR, which is based on the GDPR European regulations. So, and they haven't changed. The European GDPR hasn't changed. So really, the fundamental and key thing is the flow of data. Now we're not part of the EU and we're deemed a third country. It's how you deal with transferring of international transfer of data, sorry. But everything else should be the same.
Yeah, should be the same, shouldn't it? Somebody's asked, can you rely on SCCs for transfers to the US? Potentially, yes. It's one of the measures you can take to put in protections, and because they require quite a lot of information on the security of data, then I would say yes, that is one measure you can use, definitely. And somebody said, if our European headquarters is listed as our DPO and we don't get adequacy, do we need a UK DPO? We don't have BCCs. That's what a lot of people are doing, isn't it? Is having offices in Europe, and that's where they're centralising their server, so that's where the data is processed, so that it will be protected under European law. It's whether it can be transferred. It's whether it can the UK, isn't it?
Because we're a third country, so it's hinging on that adequacy decision. Do we need a UK?
There still could be a challenge, I guess, if the data was processed in the UK for EU citizens, that will be the challenge. But if it's UK citizens in Europe, that's okay, because Europe have the adequacy status. I guess it depends on which way the data's been transferred, and it could be both ways in that situation, I guess. So yeah, interesting questions. I think that's all. I think I've covered them all now. Hopefully, if I've missed anything, we will check through at the end and come back to you direct, because we did have quite a lot. So I was trying to filter through them as quick as I could. But yeah, thank you very much.
Thank you, everybody.
Just got one final poll to ask you, just in case any of you want any further help. So it is, if you want us to contact you with any more information or any of our training or anything else, just let us know. Did I launch it? I think I did, yes. So it's, how can we help you provide support to your staff? If you want any more information on any of this, or anything else, just let us know and we will follow this up afterwards. No obligation, it's up to you. Just some people have found it useful for us to follow up afterwards. I'll just let that run through, and I will let you know that we have now posted our next quarter's programme of webinars. We're starting to get a number of registrations for those now, but they're on a variety of topics, and we've used feedback from previous webinars to determine some of the topics, as well as things that we've been asked about regularly from our clients, and from others that we're talking to, and what we feel is sort of the hot topics coming up. So we hope you'll find those interesting. I'm going to close that now, and then I'm going to move on to show you what they are. So the next batch, we've got one next week on employing people, 10 things you need to get right. We've got how to deal with bullying and harassment, and then we're looking at coronavirus returning to work after lockdown as things open up. So Victoria's doing a combined webinar with our health and safety consultant, Dominic, and they're going to cover both the health and safety and the HR aspects of returning to work. There's plenty to consider there. Then we're going to move into how serious allegations can be handled safely, all about protected or without prejudice conversations and the difference between the two. And then remote working, how can you manage performance? As we move into a lot of people looking at hybrid working or flexible working, or not even coming back to the office. So some of the concerns, if they're going to do it on a more long-term or permanent basis, is how to manage individual performance. We're then doing a series of webinars with a partner of ours on 7 key successes for a business. So it's sort of an accelerator program. And these are running on Wednesdays through April, May and June. And so if you're interested in those are all now also posted on our website. And finally, just to let you know, we have some delegated training courses that we are running. The health and safety ones are at the Kettering Park Hotel at the moment. The equality and the disciplinary ones are virtual training sessions. So if you're interested in any of those, do sign up. There's some special deals if you want to attend more than one. And we can run any of these courses and many more in-house as well. Just contact us and let us know if you're interested. If you go to the link on our website, it tells you about all the different options. We also do e-learning and various other things as well. And finally, if you want to stay in touch and if you want to be updated on when we get to hear about adequacy statement and things like that, do sign up for our newsletter if you haven't already. And as always, let us know if you have any further questions. We welcome any feedback because that helps us inform us for future webinars. And that just reminds me to say thank you. Thank you to you all for attending and with some really interesting questions. We hope you found this informative and useful. And good luck to everybody with their data protection arrangements going forward. As I say, if we can help you in any way, do let us know. And thank you to Victoria for running the webinar for us today.
Thank you, everybody, for coming.